number 23, which was handed over on the last occasion. My lords may just have that. That will remove
My
any
lords,
doubts which my lords may have.
I
28th of
think
November 23.
I think my learned colleague is not entirely correct in making that statement for the reason that even on
I
28th
think
of November,
we should not go into all that. We should not go into all that. So long as everybody is consensus that there is something pending before the apex court, whether it is a petition before the bench or it is a petition challenging the order of the registrar. So there is still something pending, and there is a possibility of the order being amended or may not be amended. We don't know.
Of
We'll
course.
see in the future. So we'll take it up after some time.
my lords, may I
When
only
is it
make
listed?
one? I make one submission. and
As
I
of
leave
now,
it
the
to my
website
lords
shows
there.
11th of January.
After, I just make one
We will
submission
take-
and I
we will
leave it
take
to
it
my
up.
lords.
Just a minute. We will take it up in the last week of January. Will it be all right?
I
lords will
leave
do
it to
that.
my lords in that event. My lords may take it up even uh,
All right.
in the third week or wherever. If my learned friend says it's 11, it's only next week. My lords may take it up week thereafter. And my lords, we will ascertain and we will request the court to deal with this issue because, my lords, it affects us.
Lords, can I just take 30 seconds if my lords may permit? Can I just take 30 seconds? Lords, can I just take 30 seconds? My lords, in writ
So we'll
petition.
take it up in the last week of January.
My lords, can I just take 30 seconds if my lords may permit?
Yes, yes.
My lords, in writ petition 661 of 2023, writ petition 661 of 2023, the Honorable Supreme Court in a 3-judge bench has decided the issue in the MA. The issue in the MA is simply this, that post 2018, whatever notifications have come in, those they should be regularized up till the judgment date. And this issue, we have tendered a copy and we have filed that copy also, my lords. A 3-judge bench of the Honorable Supreme Court has already decided this. The matter is titled Bhagwan Krishnan versus Union of India. So therefore, what is happening today is, my lords, out of the 23,000 posts which were in state of MP, 8,500 have been taken by these B.Ed students or these B.Ed candidates. And they are enjoying, my lords. See the fallacy, my lords, they are enjoying the appointment which has been done in contravention of court orders, my lords. So therefore, it is in their vested interest to delay the matter. My lords may appreciate this point, that when the Honorable Supreme Court in a 3-judge, in a writ petition specifically with this issue, where subsequent actions have been nullified, and I can tender that, my lords, my counsel assisting physically will tender that judgment, 3-page judgment of Honorable Justice Bose, saying that all subsequent actions of 18 have been nullified. That is number one. Number two, my lords, that today, if these 11,500 students, the candidates are out, my lords, I will get in. That is what the petition is about. And thereafter, there will be another MA, then another MA, my lords. This will continue, my lords. That is the entire
There is a
problem
lot
that
to
we
be
are
said
facing.
about that Bhagwan Krishna order, my lord.
Sir, if you don't mind, sir, if you don't mind,
It's
sir, if you
completely
don't
different.
mind, I didn't. Sir, if you don't mind, my lords, that message needs to go very rightly, my lords, that there is a reason why this is being delayed.
No, we are
It's
not
about to-
sharing, please. We are not sharing the matter on merits right now. So please don't enter into merit arguments on merits. We
Well,
are
can I just
trying
put it in
to
this in one
fix the
line?
date so that we may not preempt the Supreme Court.
My lords, can I just put it in one line, my lords? Just the last line, I won't take just one line, my lords. There are 2 previous orders of this court that the matter may be disposed of in terms of the Supreme Court order, my lords. That is what I am praying, my lords. Whatever may be the future development, it is always subject to that. But today there is an order of the Honorable Supreme Court. There are 2 previous orders of this court, my lords. One in September, one in October, my lords. And it categorically records that the issue here is covered by the Honorable Supreme Court's order, my lords. So all that I am praying, we are praying is, my lords, it may be disposed of in terms of that, my lords. Whatever may be the subsequent developments, parties have their own rights, my lords. I'm sorry for pushing it, my lords.
All right.
My learned colleague has a point. As on date, there is no variation, there is no modification, there is no clarification. On the contrary, there is a rejection by the registrar. So therefore, the judgment of the Honorable Supreme Court stands, and that judgment is passed today about 8 months. It's passed about 6 months back, and there is no variation. If they were so anxious, they have taken steps. They having not chosen to take steps, and people standing and enjoying. So there is a vested interest.
Here were interveners in the Supreme Court.
Not on merits, please. Let the court declare the order. after hearing the learned counsel for rival parties, and the fact which has been brought to the notice of this court, that the application for clarification bearing number 39986, no,
No, miscellaneous application number 2206 of 23.
double 206 of 2023 is still pending consideration before the apex court and is tentatively listed before the bench on 11/1/24 as per the website of the Supreme Court. It would be appropriate to await the verdict of the apex court. Accordingly list the week commencing 29th of January.
My lords, may I make one request for an observation therein, if my lords choose that? My lords, they cannot
Yes.
on one hand keep pressing that an application is pending, on the other hand take no steps to have that taken up. My lords, on the next date, please,
There-
it can
there
be
is a judicial
recorded that
order.
it is for them to have that application heard, or if it is not heard, and then my lords will proceed with the matter. Because on one hand, they will not move that application before the honorable court, take no steps to have it listed. They will come back as time and again and press before
And
my
when
lords to
it
say
is
that there is.
listed,
No, no, there
was
is
filed when? This MA.
It was
My
filed
lords,
in September,
this-
my lord, September
28th of
23.
November is the order by Justice Bose's bench
22nd,
September 23.
requesting the registry to put it up before the Honorable Chief Justice of India for constituting the special bench. So unless the special bench is created under the orders of the CJI, it cannot be done, madam. There is little the petitioner can do on that. It is
Alright.
entirely the prerogative
you
of
can
the
always mention a matter for constitution.
Anxiety has been expressed. Next paragraph. Anxiety has been expressed by the counsel who are representing the B.Ed appointees.
No, we are the delayed.
The petitioner.
No, sorry,
Yes.
the petitioners who could not be appointed and whose vacancies have been occupied by B.Ed appointees.
Yes.
That the B.Ed appointees who have filed this MA 2206 of 23 may delay the matter. Next, in view of the above, it is observed, this court deems it appropriate to observe that if on the next date of hearing, no clarification is granted by the apex court, then this court will be free to decide the matter of merits.
I'm obliged, my lords, extremely grateful.
Deeply grateful, my lords, deeply grateful.
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 Grateful.